Please the débat. The honourable member for Vaughan Woodbridge.
Thank you, Madam Speaker. It's a pleasure for me to rise and speak about this historic agreement. Madam Speaker, my comments today on CETA will deal with the investor protection section of the agreement. But before I begin, I must comment, in my opinion, on what is the significance of this agreement in the current global context. Firstly, as the chair of the Canada-Italy Interparliamentary Group and as a dual European-Canadian citizen, I must congratulate those that worked on the agreement, acknowledge the judicious and diligent work to complete the deal. Auguri, félicitations, and congratulations to our Minister of International Trade and the Minister's entire team. Canada is a small open economy and we are trade dependent. Trade generates growth and good middle-class jobs, and this deal will do that. At a time in world history when it seems that walls are building around us rather than being breaking down, and populist rhetoric is providing false hope, the importance of CETA is not lost upon me. This view is from both sides of the Atlantic. The CETA agreement is a progressive trade agreement that will deliver positive results and opportunities for citizens in the European Union and Canada. For my home province of Ontario, CETA will help drive economic growth and create stable and high-paying jobs for generations. The European Union is already Ontario's second largest export destination and second largest trading partner. Once enforced, CETA will eliminate tariffs on almost all of Ontario's exports and provide access to new market opportunities in the EU. A simple few facts, Madam Speaker. The EU is Canada's second biggest trading partner after the US and accounts for nearly 10% of its external trade. Trading goods in between the European Union and Canada is worth almost 60 billion euros, roughly about 80 to 90 billion Canadian dollars a year. In 2013, European investments in Canada were estimated at 225 billion euros, while Canadian direct investment stocks in the European Union amounted to more than 117 billion euros. Prior to CETA's entry into force, only 25% of the European Union tariff lines on Canadian goods were duty-free. Upon CETA's entry into force, the EU will remove approximately 98% of its tariff lines. Once CETA is fully implemented, this will increase to 99% of all of its tariff lines. Madam Speaker, CETA, we should be proud of it, is the most progressive trade agreement ever negotiated. It will help redefine what trade can and should be. It will lead to increased prosperity here in Canada, create good-paying jobs, and help strengthen the middle class. It is also a groundbreaking agreement in opening the doors to increase access to the EU market for Canadian companies. CETA sets new standards for trading goods and services, non-tariff barriers, investment, government procurement, as well as other areas like labor and environment protection. Just as important, the agreement will also help facilitate investment, a significant factor in achieving prosperity and job creation. Foreign direct investment, commonly known as FDI, is an important driver of economic growth, with new investment by foreign firms having the ability to provide a boost to national income and to create jobs for Canadians, good middle-class jobs. Foreign investment here in Canada and Canadian companies investing in the EU can also promote trade by facilitating value chain linkages and improving access to new technologies. And not only will CETA help facilitate foreign investment, it sets a new bar for investment protection. One of the most important things our government did right after taking office was listen to the critics of CETA. Constructive criticism, Mr. Speaker, both in Canada and in Europe, and to understand some of the legitimate anxieties people and organizations and governments had. We heard many concerns regarding the investment protection provisions in CETA and have worked with Canadians, including industry and civil society alike, and with our European Union partners to address these issues and to prove with CETA that progressive trade policy is possible. Our government fully seized the opportunity and developed a new and improved approach to investment protection provisions. Mr. Speaker, a significant innovation in CETA is the transformation of the mechanism for the resolution of disputes between investors and states. CETA marks the first international trade agreement that establishes a permanent, I repeat that, a permanent tribunal in order to hear claims by investors alleging that states have breached investment-related obligations. The CETA tribunal will consist of 15 members appointed solely by Canada and the European Union. Ethical requirements will be central to the process leading to their appointments, including not allowing members of the tribunal to act as counsel or expert witnesses in an investment dispute under any international investment agreement. Members will be appointed for a 5-year term that may be renewed only once. Individual cases will be heard before a 3-member division of the tribunal, and those members will be selected on a rotation basis, ensuring that the composition of the division is random. Such innovations address the concerns about a perceived lack of arbitrator independence and will give greater legitimacy to the dispute resolution process. Moreover, as the members of a division hearing a specific case will be in a position to consult with the other members of the tribunal, we expect the coherency in decisions will also be much improved as a result. In addition to the first instance tribunal, CETA will establish a permanent appellate tribunal, thereby creating another precedent in international investment law. The appellate tribunal will function in a very similar way as the first instance tribunal. Its task will be to review decisions that are contested by either the foreign investor or the respondent state. In time, Mr. Speaker, the first instance tribunal and the appellate tribunal will develop a body of decisions that will constitute an effective jurisprudence. And this, in turn, will create greater legal certainty for both foreign investors and governments. Very important, Mr. Speaker, that we have this. The innovations made to the mechanism for the resolution of disputes are certainly significant ones that our government is proud of. But there are other innovations of the CETA investment chapter. We have closed the door to provision shopping by clarifying that investors cannot seek to import provisions from other Canadian or European trade agreements through CETA's most favored nation treatment article. CETA encourages the use of domestic courts by suspending the timelines for the submission of a claim while domestic remedies are being pursued. We added an article on mediation to encourage early settlement of disputes without recourse to the CETA tribunal. We have provided CETA with a mechanism for the early dismissal of frivolous claims. We have taken small and medium-sized enterprises into consideration and have added provisions which make it easier for them to access the mechanism for the resolution of disputes. We have made it mandatory for an investor who submits a claim while benefiting from third-party funding to be transparent and disclose the identity of its funder. And important, we have established a committee that provides a forum for the CETA parties to consult on difficulties that may arise regarding implementation of the chapter, as well on possible improvements to the chapter, especially in light of experiences and developments in other international fora. It has also been Canada's practice, long-standing practice, to prevent so-called mailbox companies from benefiting from Canada's trade agreements. CETA is no different. In order to be considered as an investor under CETA, a European Union enterprise that is owned by interests of a third party is required to have substantial business activities in the territory of the European Union. It cannot simply establish a mailbox company in the EU for the sole purpose of gaining access to the dispute resolution mechanism of the CETA. Finally, the CETA demonstrates, Mr. Speaker, Canada's continued leadership with regard to promoting transparency in the dispute resolution process. Under CETA, all hearings are open to the public, and all documents submitted to or issued by the permanent tribunal are made available to the public. The changes we made to CETA in addressing the important issues voiced by Canadian and EU citizens alike represent a starting point in the development of a progressive trade agenda between a progressive Canada and a progressive European Union. This is an agenda that is linked to the government's domestic policy focus on reducing inequality and enhancing inclusive growth through such things as investments in infrastructure and increasing the child benefit. The idea is to ensure, Mr. Speaker, that trade policy makes a more meaningful contribution to this overall agenda, and to ensure that trade is done in a way that Canadians and our trade partner believe works for them. Canada will continue to seek ways to enrich the economic relationships we have with valued partners with the aim of achieving prosperity for all Canadians. However, it is so important, and I repeat that, it is so important to our government that we ensure that this is done in an inclusive and a responsible manner. and we're seeing this approach realized in CETA. I am very proud to stand here to speak on this agreement. I believe it is transformational, and in the context of where we are in modern-day history, very, very well needed. Mr. Speaker, thank you for this time.
Questions and comments. The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and I appreciate the fact that my honourable colleague has focused on the investor-state provisions. When I have an opportunity to speak at length in this House, I will focus on the investor-state provisions. And while it's clear that there is some improved transparency on the investor-state provisions within CETA, I put it to my honourable friend that we have, in this agreement, not provided for fairness or independence of the adjudicators. In fact, in this, really, it's quite bizarre, but it is the case that under CETA, the adjudicators, so-called judges, will be able to work on the side as advocates. So in the words of Professor Gus Van Harten, the leading expert on this within Canada from Osgoode Hall Law School, he wrote, the last aspect of this revised text, what I just referred to, suggests that a way has been cleared for the same clubby crowd of investor-friendly arbitrators to dominate ISDS under CETA, close quote. We still have, essentially, a more transparent, but nonetheless, kangaroo court.
Honourable member for Vaughan, Woodbridge.
I thank the member from Saanich Gulf Islands for her question and intervention. What I will say is if you look at the document and you actually go to the European Union website where they talk about in detail of the investment protection system, one of the areas they talk about is with regards to the members on the tribunal, the rules that govern the members that sit on the tribunal, and to prevent what's called double hatting, and that's the term that I think the member is referring to, where a member of the tribunal also works in parallel as counsel and expert in other investment disputes for the entire duration of their appointment. This is actually forbidden within the agreement. This is forbidden in CETA. So there are safeguards with regards to the independent investment dispute resolution system. There are rules governing the members of the tribunal. There will be full transparency with regards to the proceedings, and there will be a ban on frivolous claims. I think that is a very strong component of this trade deal. I think we need to applaud that and make sure we state that. Thank you, Mr. Speaker.
Questions and comments. Question commentaire. The honourable member for Caribou, Prince George.
Thank you, Mr. Speaker, and I want to thank our honourable colleague for, I thought, a very good presentation. I'm going to change my line of questioning away from the ISDS. I thought he explained that fairly well. I would like the honourable member, through you, Mr. Speaker, the Liberal government has been in discussions with the Atlantic provinces regarding CETA Fisheries Investment Fund. And through you, Mr. Speaker, I'm going to ask the honourable colleague, how is the government, or is the government going to fulfill their commitment to help Atlantic provinces for the changes that they've made through this agreement to their processing requirements? Thank you.
Member for Vaughan, Woodbridge.
Thank you, Mr. Speaker, and thank you to my colleague for that question. Thinking about what international trade brings to Canada and the benefits it brings, one of the things that we need to look at are industries that may be impacted by trade deals. We know that overall we are better off with trade. We've seen it from the Canada Free Trade Agreement to NAFTA to other agreements that we have in place internationally. We know trade deals create good paying jobs, whether it's in services, goods, manufactured services, manufactured goods, and so forth. With regards to looking at various industries, what we've seen so far is the government step up to the plate, run its consultations with the dairy industry. I would be haphazard to guess, and I would conjecture that the same thing would happen to other industries. They may be impacted. So in this case, the fisheries industry on the Atlantic coast. I grew up in northwest British Columbia. There was a fishing industry. Once there was quite vibrant. It has now dissipated somewhat, unfortunately. But we need to ensure that when there are losers in trade, that they are being looked at. We need to get away from the fact of just looking at the winners, and we need to look at industries and groups that may be impacted and make sure programs are in place to help those associated industries and geographies. Thank you, Mr. Speaker.
Resuming debate, the honourable